Let's talk about demonstrative evidence. Let's talk about the purpose. Why do we do it? We want to educate jurors. I mean, the point of everything we do in our case is for our side to win the case. So don't just create demonstrative evidence because you've got an extra $10,000 lying around. Make sure that it actually has a purpose that will move your case forward. To simplify complicated concepts. That's one of my favorite things to use demonstrative evidence for. We have a machine. Nobody can figure out how it works. I want to illustrate how that works in a manner that moves the case forward with the two goals of all trials in mind. When we create demonstrative evidence, it's going to have a purpose. It's either going to help me in my liability case or it's going to help me prove damages. Occasionally, you get the double header and it does both. But when you're thinking about your case, think, what do I need to do to convince people that we should win? And once we win, is there a way that I can show them these damages, as Jeff pointed out earlier with the artificial fingertip, that this is really a bigger injury than they perhaps thought. It's got to have a purpose. You know, we're not dogs. People say, why do dogs do certain hygiene? Because they can. It doesn't go that way with demonstrative evidence. I remember I was trying a case in Augusta once, and this company had this. I can't stop now because they're wondering what the next 12 are going to be. But they all wish I hadn't shown them the first 8, and by the time I finish all 20, this is going to be a nightmare. So just because somebody tells you that they have a great idea for demonstrative evidence, don't necessarily believe them. Make sure it matches your liability or your damages purposes. Every slide, every item in that courtroom's got a purpose. You don't do anything once you say, yes, Your Honor, the plaintiff is ready, that doesn't have a purpose. In fact, it begins prior to that. Keep in mind, when your plaintiff is wandering around the courthouse and he's got the cane that works from the time he enters in the courtroom, but he doesn't need it in the hallway, that's going to be demonstrative evidence that's going to come back to haunt you. Does it prove liability? Does it prove damages? Don't let it confuse the message. A lot of people love to put words with their video. Why? Well, because we can. But we can only learn, most of us, one way. We either are listening or we are reading. But you better be careful. It's going to end up like that streaming stuff they put at the bottom of CNN. You can't pay attention to the streaming stuff and you can't pay attention to the talking heads, so you end up at the end of the 15-minute newscast, you don't know anything except that Iran had a bomb that might have killed somebody's pigeon. I mean, that's how confused it gets. So you've got to make sure that you don't let your demonstrative evidence confuse your message. Keep in mind, this stuff, good demonstrative evidence, takes time. Even if it doesn't take a lot of money, it takes time. You want to test it. If you show somebody something that's demonstrative and they say, I don't understand that, and you argue with them, you're a moron. All right? The point is, it should speak without you having to explain why the viewer's an idiot for not understanding your $10,000 slides. If that's the case, you need to start over because it's got to be understandable by somebody other than the plaintiff's trial team. Keep in mind that visual images work. Look at this slide. This is the difference in retention rates when you tell them, which is light blue, you show them, which is Carolina blue, or you tell and show. Look at the difference at the end of a third-day car wreck case. A little run-of-the-mill 3-day trial. If you've shown them and told them, their retention rates are amazingly better than if all you did was tell or all you did was show. One of the things we talked about earlier when Richard was talking was the idea of focus groups. We had a case where the question was the definition of unreasonably dangerous, unnecessarily dangerous, I'm sorry. Well, I couldn't quite figure out what unnecessarily dangerous meant. But what this focus group told me was, here's danger. Anything beyond absolutely necessary danger was unnecessary danger. We created the bottom part of this slide, and we had no danger, unnecessary, unreasonable, and unacceptable danger. And they told me in the focus group, well, acceptable danger is right here next to no danger. They didn't like the concept of danger. So it helped us explain it in a way that was very understandable. And you can always use a picture like a burden of proof. You do it physically when you may be doing your opening or closing. You know, we as the plaintiff only have to prove our case by a preponderance of the evidence. Many of you have heard about on CSI, you know, beyond a reasonable doubt. Well, that tilts the scales like this. All we've got to do is this. Of course, our evidence will indeed tip it that way, but think about yourself also as demonstrative evidence. We had a medical negligence case, and we had a shadow jury. And at the end of the first day, I took up their notes, and I'm reading their notes that night, and then nobody understood standard of care. Well, we'd had what I thought was a spectacular expert witness explain to us standard of care and how this doctor had breached it. And nobody got it. Nobody got it. It reminded me a little bit of what Clay was saying. We had two of the jurors whose kids were going to be treated by the defendant doctor within the next 6 weeks. The judge had been the defendant doctor's patient. It's tough venue. The next, we met with our expert that night and we said, how can we explain the standard of care? And he said, well, look, standard of care is right here in the middle. If you're out here in a research study, you do that. We're not trying to hold these doctors to over here. We don't want them to be research centers. And we're not trying to say they should have done this. This is what they did. All we're asking for is what the average person does. That night, I read their notes, and they said this image did it. This little demonstrative evidence was the definition that they stuck with the rest of the trial, and we circled back to that with all of our witnesses. Too often we think of demonstrative evidence only as useful in trial. Maybe we'll put it in mediation. Use it to illustrate your briefs and affidavits. In this case right here, I've got, on the right we have a case that Steve Thornton and I worked, and the question was how this guy got crushed against the roof of a building by a scissors lift. And this is the way he was found, just with his neck between the OSHA rail and the roof, dead. So we had to explain this, and we had these illustrations and cartoon figures created so that we could put this in our brief so the judge could see that this can't happen in the absence of a product defect. We found it to be very good. When my staff read it who didn't understand the case beforehand, when they read it with the pictures to the left, they said, aha, now we understand what you've been telling us about. Similarly, there was a case involving another piece of industrial equipment, a rough terrain forklift, and the question was how the insides broke. We embedded photographs within the brief. The reason I put word limits, not page limits, if you're in front of the United States Court of Appeals to the 11th Circuit, you got two choices. You can go with a 30-page limit, or you can go with a 14,000 word limit. If you go with the 14,000 word rule, you can put all the pictures you want in there. You can go 45 pages. If you don't take advantage of that to get the equivalent of another 5,000 words, well, I just don't know what to say to you. We're going to talk about how to use it to explain liability. All right, this is a case where we're going to talk about how a handbrake works on a rail car. Let's see if I did that right. Whoops. Let me go back. The question was, what happened here? Now, we're not going to watch the whole animation, but this is an animation about a runaway rail car. And it gives you a sense that what we wanted to do was to educate the jury about the physical scene and how the car ran away and how it was moved around the yard. We'll go through here. And there was a point at which the operator had to operate the handbrake, and so we show how the handbrake works and what this does to the handbrake shoes. Our theory in this case was that there was a blockage of a part of the handbrake called the bell crank, that it was being blocked because it was out of adjustment. And this is the bell crank here, and you can see it gets blocked. And when that occurs, you'll see that it stops the brake shoes from going up. Same amount of effort, but it stops the brake shoes. And then we said because it didn't have good brakes, the car ran away and ran over our client. And we sort of concluded it that way. Now, that's one way to illustrate, a right expensive way, by the way, to illustrate how the handbrake works. The other way is just photocopy it out of a book. Use Photoshop, add the words you want, zoom in on how the handbrake wheel works, highlight back to the bell crank, and show them how it works. Now, depending on the level of injury, depending on the level of sophistication, depending on what you think best suits your needs to illustrate this principle, you could choose one way that's absolutely free or the other way, which is several thousands of dollars. So we can do it the way we just said with those slides, or we can do an animation. We're going to get to the same point. And my point to you is not that one way is better than the other. It's that each has their place in a given trial. And our job as advocates is to figure out the one that best suits that case's needs, both from a financial point of view and from a how complex the device is. Do you really need to animate it? Now, we could have brought in a full-size handbrake into the courtroom, which we eventually did also. But we wanted a combination because you can't see inside. We couldn't bring in a rail car. So we wanted to show how when you tighten it up, the rail shoes move towards the wheels and what it's supposed to look like when it's properly adjusted. Now, another way that we can use to talk about liability is we might illustrate the dangers in a particular item. These particular warnings were to be used on a forklift. Our theory is that forklifts that emit carbon monoxide that are designed to be used indoors, propane-powered forklifts, smooth tires, they're marketed and sold to be used indoors, kill people. This is a known fact that a number of people every year die from carbon monoxide poisoning. So what did we feel like we needed to do to illustrate the concept of the defendant's failure to warn? We simply had a warning created. And the warning tells you exactly what you need to know. This forklift produces carbon monoxide. That will cause severe illness and death. Then we went on because that's not enough. You wouldn't know you'd been injured until you were severely injured or dead, which is a little late. So we felt like if we told them that if you get nauseated, if you have a headache or drowsiness, or you think you have the flu, get fresh air. We tested this, and indeed it was accepted by people as understanding, because without this kind of warning, people said, natural gas, propane, that's what's on my stove. The buses say clean burning natural gas. You can't die from that. That doesn't emit carbon monoxide, does it? Well, unfortunately for the people in these forklifts, they found out the hard way, it does. To recreate reality. In other words, I want to illustrate. The one we saw with the runaway rail car is one thing, but now I want to illustrate something, another railroad case. This is a grade crossing case. When we got to the scene, we were told that Our Lady simply pulled in front of a train. That's all we were told. There was no other trains around. It was double track, and she pulled in front of a train. Well, let me show you what we've got here. This is the picture that was the picture made by the police on the opposite side. Our Lady comes into this from this direction, crosses over the road, and gets hit. And when we got this picture, this is what we saw. Now, you see what we see here? Make sure you understand this. This is a still picture made by a policeman. See right there? That's another train on the other side of the road. The railroad said that train never existed. While the police are all over here, they moved that train. So we had an animator recreate that event. He takes this, dissolves the cars that are blocking the train. They disappear, and lo and behold, look, there's a car over there. We're going to see it again in a second in another approach. So we see this woman, she comes up. Here's the car that we just created from the other photograph. And here's the bad day. But for being able to take the first photograph, dissolve the offending cars, the train that actually hit her, we weren't able to illustrate how that blocked her view. Then you go one step further and you show her sight lines as she approaches this particular intersection. And you can see how it makes a difference. In other words, not only did they break the law in parking their train there, but it was a proximate cause in that it failed to allow her the sight line she needed for her own safety. It also explains why it is she ran through blinking red lights, because the lights had been activated by the stationary train, which had been there for a good while. Now, we also think about, well, we can do liability, we can do damages, but we got to connect them. We got to connect the defendant's wrongful conduct with the ultimate result, the proximate cause. We just saw how you might think about doing that in this grade crossing case by showing the change in sight lines. Now let's talk about it from a fire point of view. In this case, what we've got is the question of a trailer fire. Our theory was that one child died and another was horrifically burned because they were deprived the warning they would have gotten from a smoke detector. The defendant, we expected, would have said, it's a trailer. We don't care if you put 15 smoke detectors in there. It was going to burn so fast that everybody dies anyway. You're lucky your kid got out at all. So we have to do this. We're going to have to go and get a computer simulation of how fast trailers burn, computer simulation of when the smoke alarm would have triggered, and then see if there would be enough time for the grandfather who was in the shower when the fire started for reasons unknown to have saved his grandchildren. And when we do this, what we see is this. We've got the grandfather showering, we've got the fire starting, and he rescues one and it's too late for the other. And that's actually what happened. Now we've got the fire starting and it still doesn't happen. But now let's look at the split screen. If we put the smoke alarms in the bottom and no smoke alarms at the top, these are all, our experts have given us this data. On the left-hand side, smoke alarm goes off. He rescues one child, grabs the other child, goes out the front door, everybody lives. On the right-hand side, he just puts the fire out. It's not a problem. So we established the causal link between the violation, failure to have a smoke alarm, and the ultimate deaths. And that's good use of demonstrative evidence. You may have to use it to rebut the idea that it's impossible, much like the causal link in the last illustration. There's another case where I had another railroad case where the question was, could the man have been where we said he was at the time he fell? The railroad said he illegally rode the front end of a car and then fell down in a hole when he jumped off the moving car. He said that never happened. So what we have to do in this case is we take the basic knowns, we give him a walking speed, with 4 miles an hour is a pretty good clip. That's what he claimed his walking speed is, and I'm sticking to it. And you can see that as the train goes in, he's outrunning it. And indeed, he gets to where he hurts right before the train gets there. Just to show that you may or may not believe him, but it was at least physically possible for him to have gotten from where the train started to where he got faster than the train did. Use it to impeach the defendant. I know I've got a lot of railroad cases, but they're just so easy to sue. In this case, the question is this. Well, go back. You can use this for a variety of things. They will tell you anytime you have a catastrophically injured person, whether it's a railroad man or any kind of injury, your vocational rehab person says, you know, they can't work again. They'll put up what we call the Walmart defense. He could always get a job as a greeter at the Walmart. If that happens to you, let me know, because we actually have some publications from Walmart that says we don't want unhealthy people. We don't want them anywhere near us. So you could use that to rebut any vocational rehab person that says that. But this particular person, what they said is that my guy could no longer be a conductor. Well, my man says, that's all I wanted to do. but we've got a job for you in Atlanta. He was from Knoxville. We have a job for you in Atlanta. You can be a dispatcher working at a desk. Greatest job ever. That's what their vocational in-house person had just said. We've offered him this job, but he's so lazy, he won't take it. Well, let me tell you what their promotional film says on their website about that job.
Railroad conductor is physically challenging. But if you're like me, that's fine, because I'm always outdoors anyway. I want you to try and stay in good shape. Rain, snow, heavy lifting, he's pushing paper behind the desk, I always say.
Well, when you show that to the vocational rehab person who's just said, this is really a great job, it's better than being a conductor, it's kind of effective use of demonstrative evidence. We'll skip this next one because Karsten's here. That was one from a case that Karsten and I are set to try, so it was a good one too. It's really good. To illustrate damages, again, to tie the machine into the damages, here we have a machine that polishes concrete. We have the device that fell off the bottom of it because it wasn't properly designed and manufactured. Then we tie that in and show how it took the man's leg off. And then we show that with the actual slides and going back to the fixation. And again, to show the extent of the injury, and you would tie these together. These are not particularly expensive. Now, those are custom made for that, so I guess they are. They're probably about $800 a board. But you can get a board like this, used in a gastric bypass malpractice case we tried, which cost maybe $50 if you download it from the Doe Report people. So you just have to keep that in mind. Then we have one involving a back surgery that went awry, and we have an overlay that peels up and you can see the inside. I took a picture of it. It's not particularly good. And then, of course, you can always go with various hardware. I want to finish with this way. Your demonstrative needs to match your jurors' needs. Use focus groups and find out what it is they don't understand and what kinds of demonstrative evidence you could use to help them understand that. If they don't understand it, don't think they're stupid. If they don't understand it, that's something that our job is to help them to meet that need. Use them to illustrate briefs, liability, damages, plan ahead, and test it, test it, test it. Don't think because you understand it and your law partners understand it that it works. If regular people on the street do not understand it, do not use it. Fix it. Thank you.